So as a lawyer, when I talk to clients and others about identity transactions, identity systems, one of the questions I get most often is, well, what's my risk? What's my liability? What are my obligations? And of course, the technical legal answer to that is, it depends. But in reality, the real answer is, we're often not sure. We don't know because the law that governs identity systems and identity transactions really isn't all that well developed. And we're not quite sure how it's going to be applied in a given situation. So what I want to do today is kind of give you a framework for what we're looking at here and basically cover these three issues. First, I want to give you a sense of the existing legal framework for identity. And I think it's helpful to know where different laws fit in that context, because that gives you an idea of A, what your risk is, but also B, what you can change and what you can have some influence on. Secondly, we'll take a look at some of the existing and developing laws that specifically are being written to govern identity systems. And then third, a few comments on how or whether we can use law to facilitate trust and interoperability with respect to identity systems. So let's start out by looking at the legal framework that governs identity systems. And I think it's important, or at least it's helpful from my perspective, to recognize that there are three different levels of law that can apply to identity systems. And once you realize what level you're looking at and how it fits in, I think it can be a big help in terms of assessing your risk and your liability. So we've got three levels. The first I call general law. This is law that's been out there for 100 years. It's not written for identity systems. It may sound like it's totally unrelated to identity systems. The second level is the newest, and that's general identity system law. It's law written to cover all identity systems. And there's actually very little of this law currently in existence, but a lot of efforts to develop this law. And then the third is the unique individual identity system rules that are written to govern a specific identity system. And I'll take you through each of these briefly, but let's start out. Here's sort of a pictorial representation of what I'm looking at with respect to these three different layers of, or three different levels of identity law. So at the top, the general law is, like I said, it's law that's been out there for a long time, not written for identity. The second level is specifically written for identity systems generally, and that's law. And then the third level could be law, but also can be contracts, but it's unique to each identity system. And that third level, of course, is influenced by the levels that are above it. So let's quickly go through these different levels and give you a sense of what we're talking about. So level one is statutes, regulations, court decisions, basically things written by governments or government agencies or courts that focus on whatever the issue is. Maybe it's the law of defamation, maybe it's the law of fraud, maybe it's the law of contract, maybe it's privacy law. All of these different laws written for a variety of purposes, but not focused on identity systems. And I've listed a number of examples here on this slide to give you a sense of the kind of law that's out there that may have an impact. And here's how that law relates to identity. So a variety of existing laws govern the collection, use, and transfer of identity information. The most obvious, of course, being privacy law, because identity information is personal data. Privacy law is going to have a huge impact on what and how you can collect the data, how you can use it, how you can share it, and so forth. But there are other laws out there as well. Contract law may become relevant for any given contracts you entered into, and a variety of other laws. We also have a variety of laws or common law that regulates the accuracy of identity information. Privacy law in some cases deals with this. Tort law deals with it quite a bit. The law of fraud, the law of negligent misrepresentation. If somebody makes an identity assertion that's wrong, that law may become relevant in determining what the liability is. Defamation law and so forth. Laws governing the retention and availability of identity information. Again, these are existing laws that are applied to identity systems sometimes not very well. Sometimes the fit is not very good, but it's law that's going to be relevant. And of course, data security law is a big issue here. And a lot of this tends toward that ultimate question of what's my liability? And the problem we have with this existing law is figuring out what your liability is as a participant in an identity system is in many cases just not clear. So then we go to level 2 law. This is law that is starting to be written, and there are a number of efforts underway to develop this kind of law. Again, it's typically statutes or regulations. It's written by governments again, but its focus is on identity systems specifically. But its focus is on identity systems generally for the jurisdiction, not any specific identity system. So the best example we have in the US is the Virginia Electronic Identity Management Law, and then of course at the United Nations, a commission called UNCITRAL is developing law for cross-border recognition of identity transactions, and I'll get more into that in a bit. But here are some of the issues that level 2 law might govern with respect to identity systems. And I won't go through all these, but these are some of the issues that are being discussed, ranging from, can I use a digital credential instead of a paper credential? Are we going to legally recognize identity assertions or identity credentials? How are we going to determine legally whether an identity system is reliable or sufficiently reliable? What are the rules for liability? What are the obligations of the parties? And then we come to level 3 law. Level 3 law is basically law that you write yourself. It can be a statute, it can be a regulation, but for private sector identity systems, it's typically going to be a contract-based set of rules written to govern the operation of a specific identity system. And in the case of level 3 law, those rules, A, apply only to a specific identity system, and B, apply only to the people who contractually agree to be bound by them. Because, like I said, they're written for a specific system and they're contract-based. But at the same time, they're law you make up. I mean, if you're designing a system, developing a system, it's rules that you make up, just like in the credit card context. When the credit card companies established their credit card systems, they wrote a whole series of rules. And you can go to the MasterCard site or the Visa site and download those rules. They're over 1,000 pages, I think, in each case. But they're rules that they wrote to govern their system. So they are level 3 rules. And the thing is, when these rules are written, in many cases, they can be written in a manner that modifies the law at level 1 or at level 2. Now, that's not always possible. There are some laws at both of those levels that you cannot change. Privacy law is a good example. Consumer protection law is another good example. Some of those laws exist for a certain, public policy purpose, and you can't, by contract, change the result under those laws. But many of the other laws you can change. Laws that deal with the calculation of damages for breach of contract, laws that deal with liability for negligence or gross negligence, things like that. You can, in many cases, contractually agree to a result that's different in the existing law. And in many cases, that's one of the important functions that system rules can serve. So here's an example of the types of issues you usually find in a trust framework or system rules, depending on what you want to call them. But business and technical rules, what kind of technical Standard are we relying on? How are we doing identity proofing? How are we doing authentication? What's the credential management policies? So forth and so on, security rules and so forth and so on, as well as legal rules that you want to make up or modify. So for example, you might specify certain warranties, or you might take the warranties that are built into existing law and disclaim them because you don't want to be held responsible for that potential liability. You can allocate liability among the parties. You can determine how disputes are going to be resolved, and a variety of other things. But these are the kind of things you will see typically in the system rules that you will write for a unique identity system. So here's some examples of those system rules. The first bullet is contract-based rules. These are trust frameworks, and I just listed a few examples there of some of the ones that are out there. The second category is system rules that are written as a law or a regulation. The EU EIDAS regulation is a system rule. The Aadhaar Act in India, the Identity Documents Act in Estonia. Those are written for a specific identity system, and they govern the operation of that system. Entities, particularly private entities that set up identity management systems outside the scope of those rules, are not governed by those rules. And then the third category is, in some cases, we see government-operated systems also using a trust framework or system rules rather than passing a law to govern their system. And Australia and the UK are both good examples of that. So again, I go back to this chart and just kind of keep this in mind as we're talking about some of the laws that I'm going to get into, because it's helpful to figure out what level you're talking about and the impact of the law at that particular level. And as I've indicated here, most of the legislative efforts that are being discussed really focus on level 2, because typically legislation isn't designed to regulate a particular identity system unless it's a government-operated system, like a national ID system that we're seeing in many countries, in which case they will pass a law to govern their own system. So let's look at some of these laws and some of the efforts that are happening. So the Virginia Identity Management Act is a law that applies to both public and private sector identity systems within the jurisdiction of the state of Virginia, obviously. But it's primarily focused on liability. In fact, I think the whole reason for enacting that statute was to try to provide a basis upon which particularly identity providers and identity system operators could limit their liability. So basically what the Act does is two very important things. One is it sets up a commission to recommend to the Secretary of Technology in Virginia an identity management standard for the state of Virginia. And I don't know if that has formally been done yet. I know the commission has been meeting for quite some time, but I don't know if a standard has yet been adopted. But in any event, the plan is for Virginia to adopt an identity management standard. Once that standard is adopted, the Act basically addresses liability as follows. If you issue credentials that don't follow the standard, or that don't follow the rules of the trust framework in which you are operating, the standard says you shall be liable for damages that result, okay? Conversely, if you issue identity credentials that are in compliance with the Virginia standard and are in compliance with the particular trust framework in which you are operating, then you have no liability. It's basically a safe harbor from liability with respect to entities that operate within the jurisdiction of the state of Virginia. So long as you don't commit gross negligence or willful misconduct. They do exclude that. But the way it's written, the way I read it, if you're negligent, simply negligent in not following the standard, for example, you're still not liable. So it's an interesting approach. I don't know whether it's going to take off or not. That'll be interesting to see. But that was the approach that they adopted in Virginia. Now, if we go to the EU, we've got the EIDAS regulation. Now, this is actually what I call a level 3 law because it governs the operation of a specific identity system. And that specific identity system is basically a system composed of countries that opt in to the system, and its whole goal is the issuance of credentials at the country level that will be accepted for public sector applications in another EU country. So it addresses a variety of issues, but the primary one is this concept of cross-border mutual recognition. So the EIDAS regulation identifies 3 levels of assurance: low, substantial, and high, and basically says that a public sector entity in any EU country must accept the credential issued by another country that has opted into the system and has met the standards and so forth, so long as that credential is issued at a level of assurance equal to or higher than the level that the country requires of its own citizens. So if I'm a citizen of France and I want to interact with the German taxing authorities and I have a substantial level credential issued by a French national ID system or whatever it might be, if they're part of the system, then the German government has to accept my credential for purposes of accessing government services in Germany in the case where it also accepts substantial level credentials from its own citizens. So its whole focus is cross-border recognition of identity. That's really the main focus of the EIDAS system. But interestingly, it also does address liability, and it's pretty strict on liability. It says member states who opt into the system, remember this is a level 3 system-specific set of rules, but if you opt into the system, member states are liable basically if they fail to follow the rules, if they fail to ensure that attribute data representing a person is attributed to the right person. The party issuing a credential, which might be the state, or might be an identity system or identity provider approved by the state, is also liable if they fail to ensure that the credential is attributed to the proper person. And there's an authentication procedure requirement, and the party operating that also has potential liability. So 2 key issues in EIDAS. One is cross-border recognition. The second is liability for failing to follow the rules. Third, I want to mention a group called UNCITRAL. UNCITRAL is the United Nations Commission on International Trade Law. They've been around for, I don't know, some 60 years, and it's a commission composed of different countries to deal with the law regarding international trade. And their goal is to harmonize and promote international trade among a variety of countries. And they develop a variety of instruments ranging from international treaties or conventions to model laws to guidance documents for countries and so forth. In the late 90s, UNCITRAL developed a model law on e-commerce, and that model law is the basis upon which e-commerce law is written in the US and most other countries. So they can have a pretty significant impact. So UNCITRAL has started the process of trying to draft international legal rules governing identity management. Unclear whether they want to make that an international convention or whether it will ultimately be a model law or something else. But the process has started. And what I've done here is list sort of the primary issues that they are currently talking about. Legal recognition of identity credentials or identity assertions is high on the list, as is cross-border legal recognition of identity systems and credentials. But they're also looking at reliability standards. How do we know when a particular identity system or the resulting credentials or identity assertions are sufficiently reliable to be legally recognized. And they're talking about presumptions of reliability and a variety of other things. They're also looking at legally defining what are the obligations of the various roles within an identity system and what's the liability of those roles as well. So as these legislative efforts, and like I say, I think this UN one could be very influential, either in its own right or in terms of the influence that it has on countries passing their own identity laws. These are level 2 laws now, because a lot of countries look to UNCITRAL for laws in this area because they don't have the expertise themselves, and they're looking for something that's been vetted and thought through and so forth. So is this a good thing or a bad thing? Well, it depends what your interests are and what your issues are, but that's part of the debate. Some would argue that passing level 2 laws governing identity systems is not a good thing, that it might inhibit future system development, that it might inhibit experimentation, and those kinds of things. But in large part, it depends on how the law is written. And that was a big issue with the e-commerce laws that UNCITRAL wrote in the late 90s, where they consciously said, we're not going to pick a technology, it's going to be technology neutral. We're basically going to deal at a very high level with some very, very basic rules, and we're not going to regulate things. We're going to use them to enable e-commerce. And if it's done to enable identity systems, then I think it could make a huge, huge positive impact. This process is ongoing. I'm involved in that process. It's anybody's guess where it will end up, but that is something to pay close attention to. And then finally, and this is a big issue at UNCITRAL, is can we use the law to facilitate trust and interoperability? And I've just summarized on this slide a few of the issues that are starting to come up. I mean, Virginia, for example, is in their law, as I said, they're recognizing a standard. They're picking a standard and using that as the basis for determining liability. In EIDAS, they're adopting standards, they're adopting LOA, level of assurance approaches, and using that as a basis for determining when a credential is sufficiently reliable to be granted cross-border recognition. Certification, of course, is a big issue that keeps coming up and keeps coming up at UNCITRAL. Should we require identity systems to be certified? And if so, certified to what standard? Certified by whom? Who authorizes or regulates the certifiers? I mean, there's a million questions there. And does a requirement for certification, because of the cost and time involved, actually inhibit the development of a robust identity ecosystem? Should we establish a universal level of assurance standard and then require everybody else to map to it? That's another big issue that's being discussed, as well as the general issue of legal presumptions. If you do certain things, should we presume that the identity assertion is reliable, or should we assume that you have no liability because you've met a certain standard? All questions that are up in the air. All issues that I suspect most of you have dealt with from a more technical perspective, but from a legal perspective, what should we carry over into law and what should we avoid and leave to the more technical situations and leave to the system rules? That's the key question. So I think that's my last slide, and I think we're just about out of time. Do we have time? If there's a question, I can answer one quickly. Oh, yes.
The new regulator, the new policies coming from California, would that be like a level 2?
Yeah, right, because California, I mean, it's very minimal, but California, if I want to exercise my rights under the California privacy law to say, have my data deleted, the law requires that I be identified, right? So that's a general requirement that's going to apply across the board. It's not written for a specific identity system, so I would look at that as a level 2 requirement. Exactly, exactly. Okay, thank you very much.
Right, thanks, Tom.